All right. Good afternoon, everyone. Good afternoon. Good afternoon. Like to call to order the Judiciary Committee meeting for Tuesday, March 26, 2024. This is our first meeting of the session to JF bills. Any remarks from my co-chair? If not, then we will jump into our agenda. Let's start at the top to begin with, although we may jump around just to keep people on their toes a little bit today, because we like to do that. But we always like to start by making our LCO attorneys who work so hard, and we're spending most of the weekend drafting up S language happy. So now that I'm done sucking up to them, I will entertain a motion to JFS Senate Bill number 2112. That is an act concerning the reviser's technical corrections to the general statutes. It'll be LCO number 3445. I got a motion from Senator Winfield and a second from Representative Fishbein, both of whom have kept our LCOs busy this weekend. Is there any discussion on the tech revisor? Any discussion? If not, Representative Fishbein, please.
Thank you, Mr. Chairman. Mr. Chairman, I move that we create a consent calendar, that we move item SB 212 to that consent calendar.
So objection to placing this item on consent? Is there objection? If not, so ordered. Let's go to number 3, Senate Bill number 349, an act concerning dyslexia screenings of individuals who are incarcerated. I'll entertain a motion for motions for JFS LCO number 3353. Motion from Senator Winfield, second from Senator Kissel. Discussion on this bill. Is there discussion? Representative Howard.
Mr. Chairman, I just, if you happen to know, the bill talks about screening individuals. When individuals screened that have dyslexia, are we going to take some action to assist them, or is that just assumed that that's something we would do, or is that the intent
Senator
here?
Winfield.
I think eventually we would be taking action, not necessarily directed by this bill, but as you probably know, dyslexia is somewhere in the order of 3 to 4 times prevalent in the prisons as it is in the general population. And depending on what state you're in, it's in the high 40s as a percentage of the population to 50+%. And that has a lot of impact on the ability of these folks to learn, participate in programs, et cetera, et cetera. So I think we want to make sure that we have a system of screening that is robust and works. And then from there, we'll have a better sense of what it is we need to do.
Okay, thank you. So as I understand
Representative Howard.
Thank you. As I understand the good chairman there, so we're trying to get a good picture of what our prison population looks like. And if it's an issue that we can address it in future sessions. Is that fair?
Senator Winfield.
That is correct.
Anything further, Representative?
I just want to thank him for his answer. Thank you, sir.
Further questions or comments? Further questions or comments? If not, Madam Administrator, please call the roll.
Roll call vote on Senate Bill 349 to JFS it to the floor with LCO 3353. Winfield,
Winfield, any affirmative?
Staffstrom,
Yes.
Flexer, Quinn,
Yes.
Kissel,
Yes.
Fishbein,
Yes.
Blumenthal, Callahan,
Yes.
Conley, Curry, Delaney,
Curry is a yes.
Delaney,
Yes.
Dillon, Doucette, Dubitsky,
Yes.
Elliott, Gaston, Gilchrist, Godfrey, Paul,
Paul's a yes.
Harding, Hayes,
Yes.
Howard,
Yes.
Johnson,
Johnson's yes.
Khan, Labriola, Lesser, Marr,
Mara's yes.
Miller, O'Day,
O'Day, yes.
Osborne,
Osborne, yes.
Havelock Tomato, Porter, Sampson, Sims. Beach,
Beach is a yes.
Walker. Wilson,
Wilson votes yes.
Godfrey,
Godfrey, yes.
Number 4, Senate Bill number 357, an act concerning control of the Union Avenue Detention Center in New Haven. The motion is a JF. Motion from Senator Kissel, second from Senator Winfield. Discussion on this, Representative Fishbein.
Thank you, Mr. Chairman. Mr. Chairman, we've had this bill on a couple of years now. I'm very concerned about the written testimony that was submitted by the judicial branch, indicating a lack of marshals in the system, indicating that also, in addition to that, there's going to be a cost of about $1.3 million to do this. The bill itself does not contemplate funding. Very concerned that now we're going to have a detention center being run in the city of New Haven where family members can't visit their family members because it's not operational, because they don't have the staff. So at the very least, they did ask that the date be pushed back. That is not part of this bill. And as I mentioned before, there's no funding. I would hope that we get there, but at this point, I can't support what's before us. So thank you, Mr. Chairman.
Further questions or comments? Further questions or comments? If not, Madam Administrator, please call the roll.
roll call vote on Senate Bill 357 to JF to the floor. Winfield,
Winfield, in the affirmative.
Staffstrom,
Yes.
Flexer, Quinn,
Yes.
Kissel,
Yes.
Fishbein,
No,
Blumenthal, Callahan,
No.
Conley, Curry,
Curry's a yes.
Delaney,
Yes.
Dillon,
Yes.
Doucette.
Yes.
Thank you.
Doucette, yes.
Dubitsky. Elliott. Gaston,
Yes.
Gilchrist. Godfrey. Paul,
No.
Harding. Hayes,
Hayes, no.
Howard. Johnson,
Johnson's yes.
Khan. Labriola. Lesser. Mar,
Mars, yes.
Miller. O'Day,
O'Day, no.
Osborne,
Osborne, yes.
Havelock D'Amato. Porter. Sampson. Sims. Beach,
No.
Walker. Wilson.
Wilson's yes.
Number 5, Senate Bill number 427, an act concerning police animals and dogs in volunteer canine search and rescue teams. The motion is a JF. Motion from Senator Winfield, second from Representative Fishbein. Is there discussion on this bill? Discussion on this bill? If not, Madam Administrator, if not, Representative Fishbein for motion, please.
yes, thank you, Mr. Chairman. Mr. Chairman, I move that we move item number 5, which is SB 427, to the consent calendar.
Objection to placing on consent, seeing none, so ordered. All right, number 8. That is Senate Bill number 445. An act concerning a jobs program for youth impacted by the juvenile justice system. The motion is a JFS, LCO number 3448. Motion is from Senator Kissel. The second is from Senator Winfield on the JFS. Discussion. Is there discussion? Seeing none, Madam Administrator, please call the roll.
Roll call vote on Senate Bill 445. Well, GFS to the floor with LCO 3448. Winfield,
Winfield, affirmative.
Staffstrom,
Yes.
Flexer, Quinn,
Yes.
Kissel,
Yes.
Fishbein,
Yes.
Blumenthal, Callahan,
Callahan, yes.
Conley, Curry,
Curry's a yes.
Delaney,
Yes.
Dillon,
Gillen, yes.
Doucette,
Yes.
Dubitzky. Elliott. Gaston,
Yes.
Gilchrist. Godfrey. Hall,
No.
Harding. Hayes,
Hayes, yes.
Howard. Johnson,
Yes.
Khan. Labriola. Lesser. Mar,
Mars, yes.
Miller. O'Day. Osborne,
Yes.
Pavlik D'Amato. Porter. Sampson. Sims. Beach,
Yes.
Walker. Wilson. O'Day,
O'Day, yes.
thank you.
All right, we are gonna turn to some House bills now. Actually, let's start with number 23, House Joint Resolution number 171, which is a resolution proposing an amendment to the state constitution to revise requirements related to the offering of bail or pretrial release to persons accused of a crime. Is there a motion?
So moved.
And a second?
Second.
Motion from Senator Winfield, second from Vice Chairman Quinn. This is a resolution that is before us for the second year in a row, which relates to an antiquated provision in the state constitution, which says that bail shall be available in cases except where there is a capital offense committed, which of course we don't have in Connecticut anymore. And I think this committee 2 years in a row has heard testimony on both sides that frankly our bail system simply is not working for those at the low end, or frankly, those at the high end, who are charged with pretty heinous crimes. I don't know that we get across the finish line this year in finalizing that, particularly in a short session. Frankly, I'm somewhat dismayed to say I don't think we do. I know that the Sentencing Commission has been working hard to try to find consensus on the stakeholders of what a new system would look like, but I do think it's important that this committee again state this year that something has to be done. If not this year, then at some point in the very near future, this legislature needs to make some hard decisions and look at our bail system that frankly I don't believe is working, and engage with the stakeholders on a replacement to that before the situation gets worse than it already is. Representative Fishbein.
I agree, that something has to be done here. If we look at some of the heinous crimes that, have come across our desks, we've seen in the newspaper over the last few years, you had the case in Shelton where the gentleman was accused of dismembering, I think it was a 3-year-old. Under our Constitution today, that individual could not be held without bail. I don't think that anybody in this room, never mind their political affiliation, would find that to be an acceptable and just pretrial situation. However, the concept of bail is supposed to be to assure that the person will participate in the lawful process of adjudication of the charges against them. So even if they were out on bail and they did that again, arguably under our system, the bail, if it was appropriate to begin with, could not be raised punitively. Can't use bail punitively. That number really, you can't change. That's as by virtue of the state constitution. So I agree that something has to be done here. I fear for where we may end up. And I certainly have my radar scope on. But for the purposes of where we are today, I think that I am in favor of at least looking at this and hope that I don't regret that. So, thank you, Mr. Chairman.
Thank you, Representative, and certainly I appreciate your support, and I do believe in order to do this, it has to be a bipartisan discussion. The states and the places where bail reform has worked, frankly, have been led from the center, and have been led from Republicans, Democrats, prosecutors, public defenders getting together in a room, and looking at a system that is more fair, more just, frankly, increases public safety beyond the system we currently have here in Connecticut. And you have my firm commitment that, as I continue to push for this year after year after year, if it takes that long, that the conversations will remain and should remain bipartisan. So, further on this, Representative Howard.
Thank you, Mr. Chairman. I intend to support this today as well, but I do want to say a couple things for the record. One, I appreciate your comments. I take them in full faith. And as I've said to you, it's long bothered me in the 22 years I've been a member of the criminal justice system as an employee that two people who commit the same exact offense, come from the same background, get the same bond. One gets out and one doesn't based upon the means. It almost seems backwards, let alone unjust. So I'm going to support this today. But one thing I do want to point out that came out from public hearing, I understand that the bail bondsmen are here protecting their entity, and I get that. But we can't ignore the fact that the bail bondsmen offer a service to the state of Connecticut that should not be ignored. They oftentimes will get individuals who are pending trial or pending disposition of a criminal offense back to this state at no cost to the taxpayers. So they do play an important role to the public that I don't want to see ignored this process. I don't represent that it would be ignored, but in truth, it's something that when we first started talking about this, didn't immediately occur to me. So I just want to make sure that I say that for the record, that remains part of the conversation. Thank you, Mr. Chairman.
Further questions or comments? Vice Chairman Quinn.
Thank you, Mr. Chairman, and I'm also in support of this because I agree that something needs to be done. There are limited circumstances, though, where strategic decisions are made during the pendency of a case to have a bond raised on someone so that the time that they're serving, they can get credit for. So we'll have to factor that in at some point, I think. But again, I think that this is going in the right direction, and particularly as Representative Fishbein pointed out, on the higher end, that there are some people whose accused act is so severe that they should not be given the opportunity to post bond. So I agree with where we're going with this, and I intend to fully support it.
Representative Doucette.
Thank you, Mr. Chair. I'm going to be a no on this again this year, and I do wholeheartedly agree that there are improvements to be made with the system. But I find it to be very complicated and very nuanced. The question of excessive bail, the Pan case from a few years ago, I think is fairly nuanced, and there is really some question there as to what constitutes excessive bail. I think it's something that requires further study, but I am a little apprehensive about the potential unintended consequences of opening it up this way. So I'm going to continue to certainly listen and hope that we have further discussion on this, but we'll continue to be a no today on this. Thank you.
Further discussion? Representative Porter.
Thank you, Mr. Chair. I do have a question. So if we end up with an amendment to the state constitution regarding bail, will that revoke the citizens of the state's right to bail?
Representative, no. What the amendment contemplates, frankly, is that the legislature will come up with and prescribe the procedure, terms, and conditions applicable to pretrial release without the constraint that currently exists that bail can only be given. The cash bail must be available, and it must be available to those who are anyone who's not convicted of a capital offense. One of the issues that has not come up yet today that I think really needs to be highlighted is there is, I believe, a real constitutional question in the state of Connecticut as to whether the pretrial release system is the purview of the judicial branch or the legislature. There are Supreme Court decisions out there and certainly rules that have been passed by the judicial branch that certainly the judicial branch believes it is their province. Yet we have weighed in at various times, including last year where we set a 30% requirement with respect to certain firearm offenses. What this amendment does is clarifies, part of what this amendment does is it clarifies that it is the legislature's prerogative and that we, and particularly this committee, would be the ones who would prescribe those rules to you, Representative.
Thank you for that explanation, Mr. Chair, and I will vote yes today to keep this moving and to get it out of committee. Reserving the right to change that on the floor if it's not anything that I feel I can support, but I do feel I can support the effort today. Thank you, Mr. Chair.
Thank you. Further on the resolution, if not, Representative Bitsky online.
Thank you, Mr. Chairman. And I too support the concept of this. But my problem with it is a little different than some of the others, is the wording of the question itself, I think for the average person is going to be very confusing. And I can just imagine this question being on the ballot and having people try to figure out what it means. I support the concept of it, but I do think it needs to be worded in a way that most people understand it, and I don't think it is right now. So I'm going to be a no for today, but I do support the effort going forward. Thank you, Mr. Chairman.
Thank you, Representative, and certainly if you want to propose alternative language, I'm happy to look at it as this moves forward. Representative Callahan.
Thank you, Mr. Chair. And as the good representative said before me, I have some issues with the bill. And I also hope that it can be a more comprehensive bill at a later date, because now we have a situation where we have individuals that are allowed to post bond in court up to, I believe it's 40,000 now after without consultation from this committee. And if someone is failing to appear in court, there's really no method in place to make sure that they're held accountable. And I hope that can be wrapped up in a future bill. But I just wanted to make that comment, as that's something I hope this committee will spend some time on as we're working on bail issues in the future. Thank you.
Thank you. Further, Representative Godfrey.
Thank you, Mr. Chairman. I have to agree with Representative Dubitsky. The question that will appear on the ballot would be difficult for a lawyer to figure out. And I am one, and I'm reading it and I'm going, I know how big the box is on the ballot. It's a little too complicated. This has to be simplified so that the average person coming in to vote and seeing this for the first time, because there's rarely any kind of effort in advance of an election to explain any constitutional amendment. We lost a constitutional amendment a bunch of years ago because it was so convolutedly written that nobody knew what it was. And so their kind of default position was to vote no until it was explained later. So I'm hoping that, as you say, can be fixed. Thank you.
Further? If not, Madam Administrator, please call the roll.
Roll call vote on House Joint Resolution 171 to JF it to the floor. Winfield,
Winfield, in the affirmative.
Staffstrom,
Yes.
Flexer, Quinn,
Yes.
Kissel,
No.
Fishbein, Blumenthal, Callahan,
Callahan, no.
Conley, Curry,
Curry, yes.
Delaney,
Yes.
Dillon, Doucette,
Doucette, no.
Dubitsky,
No.
Elliott, Gaston,
Yes,
Godfrey.
yes for Gaston.
Thank you. Godfrey?
Yes.
Paul,
No.
Harding, Hayes,
Hayes, no.
Howard. Johnson,
Yes.
Khan. Labriola. Lesser. Mar,
Mar, yes.
Miller. O'Day,
O'Day, no.
Osborne,
Yes.
Pavlik Tomato. Porter,
Representative Porter votes in the affirmative.
Sampson, Sims,
Sims votes yes.
Beach,
Beach votes no.
Walker, Wilson.
Wilson votes yes.
All right, well, let's do number 22, House Bill number 5508, an act concerning recommendations from the Juvenile Justice Policy and Oversight Committee. The motion will be a JF. Motion from Senator Winfield, second from Senator Kissel. Discussion. If not, Madam Administrator, please call the roll.
Roll call vote on House Bill 5508 to JF it to the floor. Winfield,
Winfield, in the affirmative.
Staffstrom,
Yes.
Flexer, Quinn,
Yes.
Kissel.
Yes.
Fishbein. Blumenthal. Callahan,
Yes.
Conley. Curry,
Yes, Curry, yes, sorry.
Delaney,
Yes.
Dillon. Doucette,
Yes.
Dubitsky,
No.
Elliott. Gaston,
Yes.
Gilchrist. Godfrey. Paul,
Yes.
Harding. Hayes,
Hayes, yes.
Howard. Johnson,
Yes.
Khan. Labriola. Lesser. Mar,
Mar, yes.
Miller. O'Day,
O'Day, yes.
Osborne,
Yes.
Pavlik Tomato. Porter,
Porter votes in the affirmative.
Sampson, Sims,
Sims in the affirmative.
Beach,
Beach is a yes.
Walker, Wilson.
Thank you. All right, turning back to number 9, House Bill number 5055, an act strengthening police data reporting requirements. The motion will be a JFS, LCO number 3447.
So moved. Second.
Motion from Senator Winfield, second from Senator Kissel. This is a bill that comes to us from the Office of the Governor following their investigation into the police ticket issue that this committee held a hearing on in the off session. The JFS language includes changes to section 1, which now makes the bill applicable to any person making a false statement on a law enforcement record, and changes to sections 2 and 3 were made based on the suggestions of the chief state's attorney. Really technical and clarifying changes to those sections. Representative Fishbein.
Mr. Chairman, focusing on line 117, between the words statement and found, I make a motion that we add the clause while acting in a law enforcement capacity, so that that clause would read in its entirety partially. Knowingly making a statement while acting in a law enforcement capacity found to be untruthful during a criminal, civil, or administrative proceeding. So moved.
All right, so we have a motion from Representative Fishbein. We have a second from Representative Howard. LCO, do you have the language clear? Okay. The chair considers this to be a friendly amendment. Is there further discussion on the amendment? Representative Porter?
Thank you, Mr. Chair. Question to the proponent. So is this amendment saying that if the officer is off duty, then none of this applies through you, Mr. Chair?
To you, Representative, well, I'll let the proponent answer it, actually. Representative Fishbein?
Off-duty would be not in a law enforcement capacity, so it would, the intent is to prevent one in a law enforcement capacity from doing something untruthful, so this clarifies that.
Through you, Mr. Chair. I'm just going to think about it. Thank you, Mr. Chair.
Thank you. Let me add on this. What we're essentially doing in this provision here is we're adding a new ground for decertification, which talks about truthfulness with respect to records. And so I think the proponent of the amendment is trying to make clear that just as we're doing in other parts of the bill, this is related to conduct that relates to falsifying a law enforcement record. We are not changing the other grounds for decertification, which include conduct unbecoming. So that remains existing law. What we are doing here is in fact adding additional grounds for decertification over and above those that were enacted as part of the Police Accountability Bill several years ago. I do not see this in any way as a watering down of the actions this legislature took a few years ago. In fact, I think it's an enhancement to it, which is why I support the amendment. Further on the amendment? If not, let me try your minds. All those in favor of the amendment, please signify by saying aye.
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 Opposed, say nay. The ayes have it. The amendment is adopted. Further on the bill is amended. Further on the bill is amended. If not, Madam Administrator, please call the roll.
Roll call.
Actually, hold on, Madam Administrator. I believe, let me check here. I believe this may be consentable. So Representative Fishbein for a motion, please.
Yes, thank you, Mr. Chairman. Mr. Chairman, I move that we move item number 9, which is HB 5055 to the consent calendar.
Any objection to placing this on consent? Any objection? If not, the item will be placed on consent. Okay, number 10, House Bill number 5257, an act concerning liability for damages to persons or property caused by a dog. The motion will be a JF.
Second.
Motion from Senator Kissel, second by Vice Chairman Quinn. Discussion on this, Representative Fishbein.
Thank you, Mr. Chairman. So, most people don't know, but in Connecticut, liability for a dog bite is what we call strict liability. One who owns a dog that bites someone else, you don't have to, unless the receiver of the bite is of a particular age. You don't have to prove anything bad. Basically, remedy is had. And what this bill before us does is it extends that liability not only to the owner, but also the perhaps temporary keeper of the dog. The problem comes to us as a result of, current statute. And what's before us is to make either strictly liable for those damages, which could become problematic. I mean, the scenario is where you own a dog and you leave it with the pet lodge and you go on vacation, and while the dog is in the pet lodge's care, it bites someone. Well, you, even though you are on vacation, don't have the ability to defend that, to say that you did nothing with regard to it. The remedy that for those damages, there's a judgment against you, and that could be problematic. So I understand the concern that brings the legislation to our attention. However, I don't know that this is the correct answer to this. So I do intend to vote no today. Maybe we can get to a place that I feel more comfortable, but extending strict liability in this fashion, I think, is inappropriate, public policy wise. So thank you, Mr. Chairman.
Senator Kissel.
Thank you very much, Chairman Staffstrom. I'm happy to support this bill, and I think it charts a good course for the people of the state of Connecticut. dogs, for the most part, are man's best friend or woman's best friend or all of our best friend. But on occasion, they will act aberrantly and inflict harm on an individual, sometimes quite spontaneously. I remember one time going door to door during my campaign. It was just a beautiful Saturday afternoon, and then all of a sudden, charging out from behind a house was a dog. And so I lifted my arm to sort of instinctively protect myself, and man, that dog just chomped right on it. Went right through the skin, and I needed a shot and stitches, and was able to resolve that matter with the homeowner. Whether that dog was under the care of the homeowner, the homeowner could have been behind the house. Who the heck knows? Uh, what I have learned in studying this bill and talking to advocates is that quite often there's two paths that an individual can go in pursuing damages for an injury inflicted by a dog. You can go to the owner, but if there's another caretaker, sometimes they go in that direction. Let's say it was a dog walker, but they may find themselves years down the road in a court disposition where the trier of fact, the judge or jury, typically the judge, would say you went the wrong direction. I'm sorry, there's no compensation for you. You should have gone in this other direction. Typically in Connecticut, people's homeowners insurance will cover dog bites. So there's usually not any exposure to liability by individuals if they actually have homeowners insurance. And if you don't, then there's other ways that you can protect yourselves through insurance policies. I feel that as much as we all in Connecticut know people that have dogs, and many of us love dogs, that it really shouldn't come down to an either or when it comes to an injury inflicted by a dog, and that both avenues should be available. And certainly if one is able to get compensated from one means, that would probably foreclose an ability. We're not looking through this legislation to try to get double damages. That is not the intention, but I think that this makes sure that no one gets to the end of a road either through filing a claim or seeking litigation and finds themselves without any compensation for an injury that was occurred by a dog, an animal outside their own control. And for that reason, I think that there's legal precedent for moving forward in this direction. And I think justice dictates this direction as well. And with that, I'm happy to support the bill. Thank you, Mr. Chairman.
Thank you. Representative Trubisky?
Thank you, Mr. Chairman. Mr. Chairman, in Connecticut, we have a couple of different reasons or different bases for liability. We have negligence and we have strict liability. Negligence is there to prevent people from doing what a normal, reasonable person wouldn't do and injuring somebody. Strict liability says, because of the danger of this thing, it doesn't matter if you do everything right, you're still liable if there's an injury. So dogs in Connecticut are strict liability. So whether or not you do everything correctly to make sure your dog doesn't injure somebody, you're still liable if he injures somebody. And it doesn't even have to be a bite. Somebody can trip over your dog and get injured, and you're still liable. Now, Representative or the good ranking member indicated that there are scenarios where there is absolutely nothing a person can do who owns the dog. For example, you bring your dog to a kennel or a training facility or something, and you go on vacation, as the ranking member indicated. There is nothing that you can possibly do at that point to make sure that dog doesn't injure somebody. It's in the keeper's hands. The keeper, if the keeper doesn't do everything necessary to make sure that dog doesn't injure somebody, it should be the keeper who is liable, not the owner. what this bill would do was say that even if you've done everything humanly possible and you have no opportunity to prevent an injury, you're still going to be liable. That to me doesn't ring right, because because the law should be there to encourage people to prevent these things. And if you have no ability to prevent the injury, you shouldn't be strictly liable for somebody else's act. Simply because your name is on the title of the dog. So in my district, we've had very serious, like horrendously serious dog attacks. And for a number of years, at least 5 or 6 years, I have tried to put together a working group to try to figure out ways to minimize or reduce the number and severity of dog attacks in Connecticut. This is not the way to do it. There are better and more reasonable ways to try to prevent dogs from attacking people and try to minimize the damage that they do when they do attack. Putting strict liability on somebody who may not have any opportunity to prevent or mitigate that risk isn't the way to do it. So I'll be voting against this. Thank you.
Further on the bill? Further on the bill. If not, Madam Administrator, please call the roll.
Roll call vote on House Bill 5257 to JF it to the floor. Winfield,
Winfield in front.
Staffstrom,
Yes.
Flexer, Quinn,
Yes.
Kissel,
Yeah.
Fishbein,
No.
Blumenthal, Callahan,
No.
Conley, Curry,
Curry, yes.
Delaney,
Yes.
Dillon,
Yes.
Doucette,
Yes.
Dubitsky,
No.
Elliott, Gaston,
Yes.
Gilchrist, Godfrey, Hall,
No.
Harding, Hayes,
Hayes, no.
Howard, Johnson,
Johnson's yes.
Khan, Labriola, Lesser, Mar,
Mars, yes.
Miller, O'Day,
Day, no.
Osborne,
Yes.
Havelock Tomato, Porter,
Porter votes in the affirmative.
Sampson, Sims, Beach,
No.
Walker, Wilson.
Number 11, House Bill number 5258, an act requiring state courts to extend full faith and credit to military protection orders. The motion will be a JFS LCO number 3437. Motion from Senator Winfield, second from Senator Kissel. An issue was brought to the committee this year regarding when in the domestic violence context, a protective order is issued by the military with respect to that incident, and those orders only applying on the base and not off the base. And so the question was how to have those orders have more general application and provide protection outside of the base context. We heard quite a bit of testimony this year about the due process concerns associated with the bill as it was originally presented to the committee. And the JFS language essentially says this probably is not, unfortunately, not ready for this session, and that we need to do more research and work on the due process issue and the evidentiary issues in our state courts. So we're asking the Domestic Violence, Criminal Justice Response and Enhancement Advisory Council to study this issue in the off session and hopefully make this a priority for next legislative session. Discussion? Is there discussion? If not, Representative Fishbein?
Mr. Chairman, I don't believe this item was consentable, so it is.
Okay, we'll call the roll. Madam Administrator, please call the roll.
Roll call vote on House Bill 5258, JFS to the floor with LCO 3437, Winfield,
Winfield in affirmative.
Staffstrom.
Yes.
Flexer. Quinn,
Yes.
Kissel,
Yes.
Fishbein, Blumenthal, Callahan,
Yes.
Conley, Hurry,
Carries yes.
Delaney,
Yes.
Dillon,
Dillon, yes.
Doucette,
Yes.
Dubitsky,
Yes.
Elliott, Gaston,
Yes.
Gilchrist, Godfrey, Paul,
Yes.
Harding, Hayes,
Yes.
Howard, Johnson,
Johnson is yes.
Khan, Labriola, Lesser, Mar,
Mars, yes.
Miller, O'Day,
O'Day, yes.
Osborne,
Osborne, yes.
Havelock Tomato, Porter,
Porter votes in the affirmative.
Sampson, Sims, Beach,
Yes.
Walker, Wilson.
Item number 12, House Bill number 5297, an act concerning the decriminalization of possession of small amounts of psilocybin. Motion is JFS, LCO number 3414. Motion from Senator Winfield, second
Second.
from Vice Chairman Quinn. This is a bill that is before us for the second year in a row. It seeks to reduce the penalty for possession of small amounts of psilocybin. I will note we are not legalizing psilocybin under this bill. Let's be clear, this is not a legalization bill. Possession of psilocybin under this bill would still be illegal. A police officer could still confiscate it, could still destroy it, and could issue an infraction ticket to someone in possession of small amounts of psilocybin. But what this bill does is it reduces the current penalty for very small possession from a misdemeanor, potentially 1 year in prison, to an infraction. Recognizing that there has been quite a bit of study around this drug, recognizing the potential health benefits that that veterans and others suffering from PTSD use it for, and pushing in that direction. So, is there for discussion on this? Senator Kissel.
Thank you very much, Chairman Staffstrom. I'm going to be voting no on this for a variety of reasons. We went down this path already once with the ultimate legalization of recreational marijuana. I don't have any doubts, and when we talk about psilocybin, I think we're talking about hallucinogenic mushrooms is what most people would understand. And this will give you, for lack of a better term, I'll hearken to the 60s, some kind of a trip. You're going to be seeing things or looking at things, and it's going to have a different effect on your psyche. How that impacts an individual, I don't know. My understanding was that there was a study group regarding this. They had recommended, I think, either a pilot or a further study. There was a lack of funding. So the predicate things that were supposed to take place did not take place legislatively or administratively for lack of funding. That being the case, we are here today and moving this bill along the road. And again, it's basically taking what is a misdemeanor, which is pretty low on our scale of offenses, and essentially turning it into a traffic ticket, an infraction. So it's probably going to have little or no deterrent effect, certainly not a huge one. So it's going to be utilized. Now, I don't have any doubts that there's probably some beneficial medical utilization for psilocybin. I was, believe it or not, a champion of medical marijuana. It had tremendous impact on individuals with epilepsy. And when we had testimony back in the years and years ago from parents of children with epilepsy that they just were having seizures multiple, like dozens of times a day, and only the distilled portions of the medical qualities of marijuana were able to have a positive impact. So we as a state had a very rigorous medical marijuana program, highly regulated, done wonderfully well by our Department of Consumer Protection. And I was very proud of it because we were able to tout it as one of the best programs in the country. Now, when other states in other parts of the country legalize marijuana, then the folks that were availing themselves of our medical marijuana program were down on it because the cost of the marijuana as a drug was very high. And so they were the ones, the people that were availing themselves of that program, and I've sat here year after year after year, were the primary movers in the push, or one of the primary movers in the push to legalize recreational marijuana, in no small part because they figured it would be a lot less expensive and more available. So they didn't want to jump through the hoops. And I was very sympathetic to the fact that it really should have come down in cost. So it was getting, like so many other things when it's in pharmaceutical form, cost prohibitive, and anything that helps someone's health or reduces pain or an epileptic seizure or anything else should be available at a cost that does not foreclose people's ability to access it. I get it. I don't know what this impact will have when it interacts with marijuana, with alcohol. I don't know if you have hallucinogenic mushroom or psilocybin in some form, how it impairs your ability, eye-hand coordination, and ability to drive. I have no idea as we go down this path if law enforcement has an ability to conduct a test. One of the problems that we have with our recreational marijuana right now, and I just have a question mark as to whether the increase in fatalities and traffic incidents has anything to do with the legalization of recreational marijuana. But we do have people that have this notion that if it's okay to have a little bit of marijuana and a couple of drinks, and I can mix them together, not knowing that we had people from Yale and other highly respected research institutes and universities say that it increases the dangers or the impact on eye-hand coordination exponentially. So it's not just like 1 + 1 = 2, it's like 1 + 1 = 4. So I just don't know where we are with this. And sitting on the General Law Committee and seeing my friends and colleagues, Senator Maroney, Representative D'Agostino, wrestle with where we're going with legalized marijuana because we wanted to use the process that we had, the dispensaries. But now the marketplace has just boomed. It's like the Wild West where you can have THC and seltzers and things like that. Now there's, disagreements between package store owners that want to be able to sell this versus the dispensaries that pay millions of dollars for these special license and permitting procedures. Where are we? And I just don't know. And so before we start moving another drug, whether it's in the form of a hallucinogenic mushroom, some other distilled form of psilocybin, whether it's pill form, smokable, a seltzer, who knows? If there's ability to make money off of it and appeal to the marketplace, someone's out there going to do it. I don't know where we are on that. And so I'd rather we sort of have a focused ability to do this like we are trying to do. And I oppose the legalization of recreational marijuana, but now that we're there and we wanted to have social equity and have the victims of the war on drugs, quote unquote, if one wants to perceive it that way, benefit from legalization, all of that is very complicated. And I just don't see any effort in that direction other than this first step. And I think that we should be mindful that this could be just as dramatic, maybe even more so, in its impact to our society. So I just want to be cautious. And that's why, Mr. Chairman, I'm going to be voting no today. Thank you.
Representative Howard? You want to speak? No? No, you had said, you had flagged me like you did, Representative Dubitzky. Trust me, I'm happy not.
Thank you, Mr. Chairman. I understand that psilocybin mushrooms have some potential very great benefit for people with depression, people with PTSD, various other maladies and ailments that this drug could be used to treat. I have no problem if it were a drug that were prescribed by doctors, that was used as part of as a tool in the toolbox to treat different conditions. But what we're doing here is not that, and it is not, as you say, Mr. Chairman, not legalizing it for recreational purposes. But we went down this same road with marijuana. We started out with decriminalizing, then we went to legalizing it for medical purposes, then we went to legalizing it for recreational purposes. And this year we had the highest fatality rate on the highways that we've had in quite a while, if not ever. I can't say that one caused the other, but you know, we had anticipated this was going to happen, and it happened. Whether there's a causal link or not, I don't know. Going down that same road with psilocybin, I think is a bad public policy. If we think that it has medicinal uses, let's go down that road. Let's consider the legalization or the use for medicinal purposes. But just to say that somebody found walking the street with it has essentially a jaywalking ticket, I think we're going down the wrong path. So I'll be voting against this. Thank you, Mr. Chairman.
Repo Day?
Thank you, Mr. Chair. Just real briefly, I want to associate my remarks with the good ranking member and my previous colleague who just spoke. You know, I did read and I encourage everybody to take a look at the National Transportation Safety Board's December 13, 2022 report. You know, both California and I believe every state that has legalized recreational marijuana saw an increase in fatalities on the roadways. So, you know, psilocybin, when I was asking questions there in the hearing room, I don't recall, and Mr. Chair, correct me if I'm wrong, was there any physician that testified that they are prescribing this or would prescribe this if it were legalized?
Well, Representative Day, I don't believe that question was asked or folks were asked to testify on that because we're not talking about legalization and we're not talking about someone being able to prescribe it.
No, I understand that. My recollection is there were no MDs that testified in favor of prescribing. We had heard from people who are self-prescribing it for various ailments. I don't recall, and my question simply is, Mr. Chair, if you recall, if anybody recalls, a doctor, an actual MD testifying that the psilocybin was a valid treatment for any medical issue. Is that, and I know we're not talking about that, but there was testimony about the helpful PTSD, this psilocybin being good for PTSD. Did we not hear that testimony? Am I missing something?
There was testimony from a number of proponents of this bill about how they find benefits from this drug. I think There also was a study done by the state of Connecticut a few years back that talked about some of the health benefits, and I believe the FDA has been conducting its own research. That's the testimony I recall on this.
So thank you very much, Mr. Chair. We're in the same boat. I don't recall any doctors. I do recall a number of people testifying how you need what did they call it? A trip, a trip sitter, or it was somebody, you basically needed somebody with you who was going to stay sober while you tripped so you didn't hurt yourself. I just don't see, the path of this is disastrous in my humble opinion. And I urge my colleagues to vote no on it. Thank you very much, Mr. Chair.
Further on the bill, if not, Madam Administrator, please call the roll.
Roll call vote on House Bill 5297 to JFS it to the floor with LCO 3414 Winfield.
Winfield, in the affirmative.
Staffstrom.
Yes.
Flexer. Quinn.
Yes.
Kissel. Fishbein. Blumenthal. Callahan.
No.
Conley. Curry. Delaney.
Yes.
Dillon.
Dillon, yes.
Doucette.
Say yes.
Dubitsky.
No.
Elliott. Gaston.
Yes.
Gilchrist. Godfrey. Paul.
No.
Harding. Hayes.
Hayes, no.
Howard. Johnson.
Johnson is yes.
Khan. Labriola. Lesser. Marr.
Mars, yes.
Miller. O'Day.
O'Day, no.
Osborne.
Osborne, yes.
Pavlock D'Amato. Porter.
Porter votes in the affirmative.
Sampson. Sims.
Sims in the affirmative.
Veach. Veach votes no. Walker. Wilson.
Number 13, House Bill number 5324, an act establishing secondary traffic violations. The motion will be for JF. Motion from Senator Winfield, second from anybody? Second from Senator Kissel. Everybody's asleep over here on us today. All right. Looking down to my left over here, all right. Well, I think we have a motion in a second now, finally. This is a bill that's been before us a couple years in a row, comes to us from the study group that was set up a few years ago. Discussion on the bill. Senator Kissel.
Thank you very much, Chairman Staffstrom. I'm going to support this bill again this year, although I want to give props to the chief of police up in my hometown of Enfield, Alaric Fox, former colonel in the state police and now the chief of police in Enfield. He made some excellent arguments in opposition to this. Probably when you really distill right down to it, if we are going to create something called secondary stops, or have some laws on the books where a police officer, in seeing a violation, really can't pull someone over, why do we have it on the books in the first place? And that's a good question. Nonetheless, I do recall the presentation that was made, not this year, but the year before, and it was rigorous. There was a lot of detailed analysis done of these stops for these charges. I would not say in even a majority of jurisdictions, probably in a few isolated jurisdictions, but some of these stops tend to have a disproportionate effect on people of color. And the question is why? And one could extrapolate that there's some kind of stereotyping going on here or bias, but it also could be that people in certain socioeconomic stratas tend to be certain races or ethnicities, especially in certain geographic areas. I mean, if you took a portion of any of our major cities in Connecticut, I think just it's common knowledge that they're disproportionately higher people of minority status than not. And so if there's a disproportionately high number of pullovers in an urban environment for some of these offenses, my guess is that it's going to impact people of color more than others. So it comes down to which came first, the chicken or the egg, or what's causing this. I think that there's valid arguments saying, can law enforcement utilize other tools, of which they have lots, to enforce the law and bring down crime, especially violent crime and serious crime? And I view property crimes as serious crimes. Anybody who has a car stolen, that is a huge, huge problem. And I just know that if anything happened to my home or my property, or my children, or the neighbors that I live with that I care about, I don't care what it is. Crime is crime and it's all bad. But then in the analysis that I paid close attention to, it said that in some of these pilot studies that were conducted or analyses, that when the resources of law enforcement were redirected, that it actually had a positive impact on bringing down crime. And so that while I understand that law enforcement would prefer to have this ability still intact, I don't believe that it unreasonably will tie their hands. At the same time, I recognize the very valid arguments that were made to me by Chief Fox. I have the utmost respect for him. And so I look forward to further discussion and debate on this bill. And if it does make it out of the House, then it may be in a different form than it is now. And the last point I will stress is this, as I stressed with Chief Fox. When I first sat down and discussed this bill with leadership, it had some provisions that are no longer in there now. One of the most important things that I thought law enforcement does in pulling people over is they will see if you are missing a rear turn signal or a rear brake light. It was told by proponents, oh, a good Samaritan's going to let you know if you don't have your rear lights on. Well, I don't think that that's really practical or probable. So it's probably important for safety reasons, as well as any other reason, for law enforcement to pull people over if they don't have a functioning rear turn signal or brake signal, which are really important to highway and roadway safety. And so leadership, in discussing that with me, changed the bill so that those are still offenses where law enforcement can act prospectively and pull someone over. And if that leads to other charges, then that's what it does. But I thought that that was a critical flaw in the original proposal. With that change, there's been some compromise in a direction that I favor. And for that reason and all the other reasons, I'm going to be supporting the bill today out of committee. Thank you, Mr. Chair.
Thank you. Further on the bill, Representative Porter.
Thank you, Mr. Chair. I'm just seeking clarity on what it is Senator Kissel just shared with us. This is regarding secondary traffic violations. Are we still stopping people for secondary violations? I guess is my question, for turn signals, brake lights out, etc.
Senator Winfield.
Rep Porter, if I don't answer your question, it's not because I'm not trying. I'm not 100% sure I have the answer to your question. But I think what Senator Kissel was referring to was, as we were working on this bill in the past, in an attempt to stop these secondary traffic stops, that there were some things he thought were important to leave in because of the issue of safety. And that as the conversation went forward, there was a recognition that made some sense, and those things were taken out of the list of secondary violations that would not an officer would not be able to stop you for under section 1 of the bill. And I think he was expressing both gratitude for that and how that is part of the reason why he's voting for the bill. If that's not the answer to your question, I'm happy to take another shot at it.
Thank you.
Representative Porter.
Thank you, Mr. Chair, and thank you, Senator Winfield. I guess the question is point blank, what is it that we can stop for? I was under the impression, this is new to me, that's why I'm a little confused right now. And I'll give you a hypothetical. If I have a brake light that is out, is it permissible for a cop to pull me over solely on that basis?
Through you, Mr. Chair. Yeah, yes. I mean, what we're trying to do here, and I'll just, for clarity's sake, what we're trying to do here is take some of the things that have been in this discussion for a while and make those things for which it is not permissible, if that is the only reason to pull someone over, right? So that would be the compliance with the tinted window, the license plate number against the rear window, the illumination of headlamps, failure to have 2 functioning tail lights, illuminating the registration plate, 2 reflectors, 1 headlight out, obstructed view while driving, and several other things. Those are the things that are contemplated here, but we haven't, as a committee, taken action that went to the floor of the House and the floor of the Senate and passed. So the law is as it had been. Through you, Mr. Chair.
Okay, so sorry, waiting on you, Mr. Chair.
Representative Porter.
So what you just outlined is actually, and this is a clarifying question. What you just outlined is what you can be stopped for solely on that basis. Through you, Mr. Chair.
Through Representative Porter, I think, let me take a stab at this. I think what the conversation is about is, remember, this is a bill that originally started based on a task force that was put together after the police accountability passed several years ago. That task force came forward with a list of items and said, these items should not be a reason for a police officer to pull you over. If you're pulled over for something else, you can still be charged with that violation. That original list was reduced in the sense of the original task force report and the bill we had, I guess it was now 3 years ago, had additional violations that would have been removed from the list of primary violations and made only secondary violations. The bill before us is a subset of the original list that came to us from the task force, if that makes sense. Is your question.
Thank you, Mr. Chair.
Further on the bill, Vice Chairman Quinn.
Thank you, Mr. Chairman. Excuse me, as I'm losing my voice. I've struggled with this one a bit, but I am going to support it today. In looking at the list, I think that there are a number of things that on the list that you wouldn't actually gain any knowledge of until you had the vehicle pulled over for some other reason. So those don't bother me. One that I would like us to possibly take another look at would be on the registration issues. And again, we used to have the stickers on the plates. So if you were behind a car and the date on the plate had already passed, then you probably have a registration violation, but we don't do that anymore. But I understand that license plate readers will detect that. And the concern that I have on the unregistered vehicles is that they're more than likely not insured. And I would think we would have an interest in getting the uninsured vehicles off the road in the event that they cause an accident and not where they're at fault for it. And now the victim is stuck going through their own insurance on it. But again, I am going to support this, but just wanted to air that one concern. Thank you.
Thank you. Further, Representative Howard.
Thank you, Mr. Chairman. I think the committee members are well versed in my opposition to this particular piece of legislation. And we could sit here forever and debate, how important it is to pull somebody over for unobstructed windshield or tint or the rear view mirror, et cetera. We could do that forever because sometimes it's important and sometimes it's not, and it depends on the situation. But I think that at some point in time, we need to say to our law enforcement in this state that we can trust them to make those decisions and instead of taking tools from them. Last night in New York City, a police officer named Jonathan Diller was killed, and the mayor of New York City made a statement this morning. And he said, these bad guys are violent, they carry guns, and the symbol of our public safety, which is that police uniform, they have a total disregard for. And I think he's right. And he also said that that he called it the symbol of our public safety. And I think the more that this legislature tells our police officers that we're going to make all these decisions for them, instead of give them the discretion to make these decisions as they seem appropriate, I think furthers the disregard for that symbol of public safety. And I think we need to start to shift away from that a little bit. And I just would remind the committee members that at public hearing, the executive director of the Connecticut Racial Profiling Prohibition Project testified that in fact, the stops in this state are not showing signs of disparagement. We're trending in the right direction. I think our police officers have answered that, have risen to that. And I think that continuing to send a message then that we're going to take tools away from them because we don't trust them to make the right decisions is not the message we should send. So a no still. Thank you, Mr. Chairman.
Further questions or comments? Representative Doucette.
Thank you, Mr. Chair. I'm going to support this today, although I do have some confusion, and it sounds like I'm not the only one, as to certain violations here. I note that the state's attorney submitted some testimony questioning particularly those infractions that impact on safety. We've heard a lot about, I don't sit on the Transportation Committee, but we've heard a lot about highway safety this year, and I think we can all agree and observe, and there's empirical data to show it, that that we have an issue with safety on our roads. So that's really my concern. I would like to see, and I know this bill has been around for a few years, and as the chair said, it came out of a task force, but I'm not aware that there's been a lot of specific negotiation on the language this year. I would like to see some further clarity on that, and on those again, those infractions that could potentially touch on safety. And I hope to see those discussions happen between those who are interested. I understand there are sort of maybe some subtext or some issues around this. I would hope that parties would be able, who are interested in this, to sit down objectively and look at it to seek some further clarity on that. But I will be supporting it today to get out of committee. Thank you, Mr. Chair.
Reporter.
Thank you very much, Mr. Chair. Just real quick to echo the Representative Howard's comments. The reason why there are more deaths on our highway is because people are driving faster and there are less police interactions, less people being pulled over for speeding and for other violations. That's it. And there's really even our own statistics from DOT suggest or state that we've got record amount of deaths, and it's not all due to alcohol. Alcohol death, number of deaths involving alcohol and drugs was only, I mean, one death is too many, but was approximately 68, I believe, out of the 360 some odd record number of deaths. I can't speak for my friends on the other side of the aisle, particularly my friends in the Black and brown community, and I certainly don't want to put these opinions there, make them their opinions. But with my sons driving around with secondary violations, taillight out or whatnot, and I want my son pulled over if it makes the highways less safe because he's got a taillight out. I want the highways and roadways more safe. And the way we get drugs and guns off the roads, out of the system, the number one way, at least according to what I've been told, is on these stops, police stops. There you catch them. So I I'm going to vote no, and I would urge my colleagues to vote no as well. Thank you very much, Mr. Chair.
Further on the bill, Representative Porter, second time.
Thank you, Mr. Chair. And I'm just listening to this conversation go back and forth, and I can tell you that I have some serious concerns around what's being discussed and what's being considered as permissible and non-permissible. And I do respect Repo Day for saying what he said, because there's definitely a difference between policing in his community and policing in my community. There's certainly a difference between his son getting stopped by the cops and my son getting stopped by the cops, or myself. And I have been pulled over. Um, registration, was told my car wasn't registered. Absolute lie. Got held up for about 20 minutes, then came back and said, "Oh, my bad. I ran your plates wrong." Like, he put in the wrong information for my plates. "Oh, by the way, where you headed?" I mean, then came these questions that were really irrelevant. So this is very problematic. And at this point, I will vote no today to flag this, because we're gonna have to get this right, or I can't support it. There's a dire need to make sure that this language is going to do exactly what we say it's going to do. And in my community, the bottom line is, it saves lives. We lose our lives getting pulled over for a traffic stop. So if there's something we can do, and I do, my prayers go out to the family of that New York cop. But I can tell you, policing is not the same in every community. And I would love for my community to be able to trust police like others on this committee are able to do, but there are reasons why we cannot. And I think that's something that's going to have to be solved and worked on from both sides of this, the police and the community. And right now, I don't see where this is going to do what we're saying it's going to do. So as I stated, I will be a no to flag this today. Thank you, Mr. Chair.
I want to clarify on this bill, because I think there's some confusion. So as the bill is currently written, the bill that's before us right now, if taillights are out, if someone has a taillight that is out, they can, if this bill becomes law, they can still be pulled over for a taillight that is out. It cannot be pulled over for one headlight that is out. So if you have one burnt out headlight, the other headlight is functioning, you cannot be pulled over for that. But if you have a burnt out tail light, you can be, the way this bill is currently written. Okay, with that clarification, I guess the only thing I would add is I think there's a universal agreement on this committee that speeding is a problem on our roads. I think we all share a concern about impaired driving. From my perspective, I would prefer our police officers be focused on that. Certainly, I want someone pulled over for driving at a very high rate of speed on our highways. I want someone pulled over for swerving in and out of lanes, or otherwise showing signs of impairment. I would rather them focus on that as opposed to pulling someone over for failing to have a front license plate, or failing to have a working horn, or failing to have a functioning side view mirror, all of which would be prohibited under this bill. What this bill, I think, hopes to do is focus law enforcement, provide some direction from this legislature on focusing on the more serious violations we see on our roads, and less on the ticky-tack stuff that this bill is addressed at. With that, Madam Administrator, I asked if there was any further thing on this. Representative Fishbein.
I wasn't gonna say anything, but now we heard all this other stuff. During the public hearing, the question was asked of leadership of police forces. We hear about the speeding on the roadways. Are the officers complaining because they can't stop people on the roadways because they're too busy pulling people over with license plate violations or one headlight out? It's not the case. So to say that officers, or to even imply that officers are so busy with all this other stuff that public safety and people are dying on our highways because of that, I don't prescribe to that, so I just felt I had to respond, so thank you.
Madam Administrator, please call the roll.
Roll call vote on House Bill 5324. JF to the floor. Winfield, Staffstrom,
Yes.
Flexer, Quinn,
Yes.
Kissel,
Yeah.
Fishbein, Blumenthal, Callahan,
No.
Conley, Curry,
Representative Curry votes yes.
Delaney,
Delaney in the affirmative.
Dillon,
Dillon, yes.
Doucette,
Doucette, yes.
Dubitsky,
No.
Elliott, Gaston,
No.
Gilchrist, Godfrey, Paul,
No.
Harding, Hayes,
No.
Howard, Johnson,
Johnson is yes.
Khan, Labriola, Lesser, Mar,
Mars, yes.
Miller, O'Day,
O'Day, no.
Osborne,
Yes.
Pavlock Tomato, Porter,
Porter votes in the negative.
Sampson, Sims, sorry, Representative Sims, Beach,
Beach is a no.
Walker, Wilson.
All right, number 14, House Bill number 5380, an act concerning the composition of the Judicial Selection Commission and decisions rendered by said commission. The motion will be a JF.
So moved. Second.
Motion from Senator Winfield, second from Representative Quinn. Is this bill, as the title says, changes the composition of the commission. It also looks at certain internal operating procedures and reporting by the commission to this legislature. Questions? Representative Quinn.
Thank you, Mr. Chairman. Mr. Chairman, I would like to offer an amendment in line 166. It indicates that someone would automatically come off of the approved list if they'd been on for 8 years. I would like to change the number 8 to 10.
So the motion is in line 166 to strike the word 8 and insert the word 10.
Second.
So motion from Representative Quinn, second from Senator Kissel, LCO. Are we clear? You guys are clear on the amendment? I believe the intent of lines 165 through 180 under this is to make it so that once someone has been approved by judicial selection, they've been on the list for a certain amount of time, rather than continuing on the list automatically, there would be some sort of check-in or reapplication process back to judicial selection after a period of time. The amendment seeks to change that time period from 8 to 10 years. I think that's an appropriate change, and so would consider this friendly amendment. Is there further discussion on the amendment? If not, okay, Ranking Member Fishbein on the amendment, right?
As long as I know it's not just Doug who can't remember my name here today.
You've been so quiet. I forgot you were down there.
Trying to get stuff done. Mr. Chairman, I make a motion that we move item number.
Wait, whoa. See, that's why I didn't call on you yet. We have to
Oh.
adopt the amendment.
Oh, yes. we
So
adopt-
would you like to comment on the amendment?
No.
Okay. So that, go back to being quiet. I'll call on you when it's your turn. That's why I was confused. All right, further discussion on the amendment. If not, I will try your minds. All in favor of the amendment, please signify by saying aye. The ayes have it. The amendment is adopted. Now, if there's no discussion on the bill as amended, we will turn to the ranking member for a motion.
I still can't remember my last name, but anyway, oh, okay. I guess we got to call a roll.
All right, we will call the roll then. So you're withdrawing your motion, there is no motion, and Madam Administrator is gonna call the roll.
Roll call vote on House Bill 5380 to JFS it to the floor with Amendment A. Winfield,
Winfield in the affirmative.
Staffstrom.
Yes.
Flexer. Quinn.
Yes.
Kissel.
Yeah.
Fishbein. Blumenthal. Callahan.
Yes.
Conley. Curry.
Curry's a yes.
Delaney.
Delaney, yes.
Dillon.
Dillon, yes.
Doucette. Dubitsky.
Yes.
Elliott. Gaston.
Yes.
Gilchrist. Godfrey. Paul. Harding. Hayes.
Yes.
Howard. Johnson.
Johnson is yes.
Khan. Labriola. Lesser. Mar.
Mars, yes.
Miller. O'Day.
O'Day, yes.
Osborne.
Yes.
Havelock Tomato. Porter.
Porter votes in the affirmative.
Sampson. Sims.
Sims in the affirmative.
Beach.
Yes.
Walker. Wilson.
Wilson votes yes.
Turning to item 15, House Bill number 5412, an act concerning identification and citizenship status information requested in obtaining a marriage license. The motion is a JFS LCO 3367.
So moved.
Motion from Senator Winfield, second from Representative Quinn. This bill simply states that someone is not required to provide their social security number when applying for a marriage license. Is there discussion? Is there discussion? Seeing none, Madam Administrator, please call the roll.
Roll call vote on House Bill 5412 to JFS it to the floor with LCO 3367. Winfield.
Winfield in the affirmative.
Staffstrom.
Yes.
Flexer. Quinn.
Yes.
Kissel.
No.
Fishbein. Blumenthal. Callahan.
No.
Conley. Curry.
Curry's a yes.
Delaney.
Delaney, yes.
Dillon.
Dillon, yes.
Doucette. Dubitsky.
No.
Elliott. Gaston.
Yes.
Gilchrist. Godfrey. Paul.
No.
Harding. Hayes.
No.
Howard. Johnson.
Yes.
Khan. Labriola. Lesser.
Lesser, yes.
Mar.
Mars, yes.
Miller. O'Day.
O'Day, no.
Osborne.
Osborne, yes.
Havelock Tomato. Porter.
Porter votes in the affirmative.
Sampson. Sims.
Sims both in the affirmative.
Beach.
No.
Walker. Wilson.
Wilson's yes.
Item 16, House Bill number 5413, an act concerning the illegal use of certain vehicles and street takeovers. The motion is a JFS LCO 3452.
So moved. Second.
Motion from Senator Winfield, second from Senator Kissel. This is a bill that comes to us from a CCM task force to look at the issue of street takeovers and the use of ATVs on our roads, provides greater ability to municipalities with respect to the forfeiture of illegally used vehicles, among other things. Discussion, Senator Kissel.
Thank you very much, Chairman Staffstrom. I know that during the public hearing, I know that the Mayor Elker of New Haven wanted the ability to get rid of the ATVs that were seized. I get it. But during that day's discussion, I think there also were some, at least in the underlying bill, there would be penalties visited upon people that are merely observing a street takeover or what is alleged to be a street takeover. And my concern is just, normal passersby You know, I told my son, I said, oh, those people are rubbernecking. He didn't know what the term meant, but it's like when there's an accident or something happening, people slow down and check it out. And so I can imagine just walking down a street, if there was something crazy going on, I mean, probably my first instinct would not be to draw attention to myself by running away or something. I'd probably just try to like, what's going on? And plus, whatever's going on, your natural tendency is going to be to observe. So is that still in here, sort of a status crime of merely observing this alleged event?
Thank you, Senator Kissel. I should have mentioned that at the outset. I think as I made pretty clear during the public hearing on this, as I read the original language of this bill, there was in fact a mandatory minimum sentence of 30 days in prison for someone who stood there watching a street takeover, which frankly is nuts. So we have removed that language from the bill as part of this JFS language. I understand there may be other versions of this bill that are floating around from other committees. It would certainly be our intent that when those bills get here, they will not come back out of this committee, and this would be the vehicle that moves forward without the mandatory minimum sentences.
I want to thank you, Chairman Staffstrom, for removing that portion of the bill. I do not favor status offenses. I think we live in a free society and we need to protect people's freedom of expression, and that also includes a freedom to observe if you're not causing harm to anyone. So thank you very much, and I'd be happy to support the bill.
Further on this bill, Representative Porter.
Thank you, Mr. Chair. Just a quick question for clarification. There was something in the bill regarding revocation of driver's license regarding bystanders. And it went on to say that you could permanently have your driver's license revoked as a bystander. I know you took out the mandatory minimums, but where do we stand on that language through you, Mr. Chair?
You have a line item, Representative?
I do not.
So my understanding of the revocation was that it applies to someone who engages in certain conduct where so I'm looking at lines 105 through 108, which says that someone who engages in essentially, as I read it, says someone who engages in a street takeover when they already have their driver's license suspended. So they engage in a street takeover while their driver's license is already suspended. For a second violation, it would be a 45-day further suspension, and then a third offense would be a permanent revocation. But that's for someone who already has a suspended driver's license and engages in the takeover itself. To you.
And it does not apply to bystanders, correct?
My understanding is that it does not, but certainly we can look at that before this hits the floor.
Thank you.
Further on the bill, if not, I guess we'll call the roll on this one too. Representative Fishbein. Number 16.
Yeah, Mr. Chairman, my understanding is that number 16 is also not consentable.
All right. We will call the roll then, Madam Administrator.
Roll call vote on House Bill 5413 to JFS it to the floor with LCO 3452. Winfield,
Winfield, in the affirmative.
Staffstrom,
Yes.
Flexer, Quinn,
Yes.
Kissel, Fishbein, Blumenthal, Callahan, Conley, Curry, Delaney,
Delaney in the affirmative.
Dillon,
In the affirmative.
Doucette, Dubitsky,
Yes.
Elliott, Gaston.
Yes.
Gilchrist, Godfrey, Paul. Yes. Harding, Hayes,
Yes.
Howard, Johnson,
Johnson is yes.
Khan, Labriola, Lesser,
Lesser, yes.
Mar,
Mars, yes.
Miller. O'Day,
Uday, yes.
Osborne,
Osborne, yes.
Havelock Tomato. Porter,
Porter will be a negative to flag. Thank you.
Sampson. Sims. Beach.
Sims in the affirmative.
Thank you. Beach,
Beach is a yes.
Walker. Wilson,
Wilson's a yes. All right, I was reminded, actually, I should have announced this earlier, so the votes will be open until 4 o'clock. Should be, barring anything unforeseen, we should be done well before then, so 4 o'clock will be the time for votes to be held open to. All right, number 17, House Bill number 5418, an act concerning eligibility for participation in a pretrial family violence education program. Is there a motion? Okay, I got a motion from Representative Porter and a second from Representative Howard. Discussion on this bill? Discussion on this bill? If not, Representative Fishbein?
Mr. Chairman, I make a motion that we move number 17, HB 5418 to the consent calendar.
Is there objection to placing the item on consent? Seeing none, so ordered. Number 18, House Bill number 5419, an act concerning the authority of the Attorney General to initiate legal actions in response to alleged discriminatory housing practices. The motion is a JFS, LCO number 3440. Motion from Senator Winfield, second from Senator Kissel. This bill does much as the title suggests. It gives the Attorney General the authority to bring certain housing enforcement actions. The S language amends a statute concerning the responsibilities of the Attorney General, as opposed to the CHRO statutes, which is a better fit for the language of the bill. Discussion. If not, Madam Administrator, please call the roll.
roll call vote on House Bill 5419 to JFS it to the floor with LCO 3440. Winfield,
Winfield in the affirmative.
Staffstrom,
Yes.
Flexer. Quinn,
Yes.
Kissel.
Yes.
Fishbein. Blumenthal. Callahan,
No.
Conley. Curry,
Curry's yes.
Delaney. Dillon,
Delaney, yes.
Dillon,
Dillon, yes.
Doucette. Dubitsky,
No.
Elliott. Gaston,
Yes.
Gilchrist,
Yes.
Godfrey. Paul,
No.
Harding. Hayes,
Yes.
Howard. Johnson,
Yes.
Khan. Labriola. Lesser. Senator Lesser? Mar,
Mar, yes.
Miller. O'Day,
Uday, no.
Osborne,
Osborne, yes.
Havelock Tomato. Porter,
Porter votes in the affirmative.
Sampson. Sims,
Sims votes in the affirmative.
Beach,
No.
Walker. Wilson.
Item 19, House Bill number 5422, an act concerning hate and bias crimes. The motion is a JF. Motion from Senator Winfield, second from Senator Kissel. This bill does a few different things. First, it mandates someone convicted of a hate or bias crime participate in anti-bias or diversity awareness program or community service. It adjusts the membership of the statewide Hate Crimes Advisory Council and requires the council to examine and recommend legislative changes with respect to the intent element of our hate crime statutes. Discussion on the bill. Representative Fishbein.
Thank you, Mr. Chairman. Mr. Chairman, I'm going to support this out of committee. However, I would like to flag a concern. Initially when this bill came to our committee, I'm of the position that when somebody pleads guilty or is convicted of a hate crime, that there should be something in addition to the penalty itself. Currently, under our law, the convictee attending bias or diversity awareness program is discretionary to the court. So one may be more apt to plead guilty with the understanding that as part of that plea bargain, they would not be required, because that was part of the deal. What you may end up happening here, however, is an individual apt not to plead guilty because they would be required to go through this training. So I think it's a possible unintended consequence of this. Certainly I want these things to be dealt with and addressed, and maybe it's better off if all of these cases had to go to trial where somebody had to actually testify, what happened bad and how that affected them and all of that stuff. But a lot of these cases get plea bargained out. So a prosecutor may be more apt to undercharge an individual, understanding that as a part of being convicted of the actual hate crime, that this is a statutory requirement. So I am going to support it out of committee. I don't know if this could possibly be changed in some way, shape, or form to address my concern. But obviously, burning a cross on somebody's lawn or painting a swastika on their door is not something that I find is acceptable by anyone. I just don't know that this is the legislation to address that. So thank you, Mr. Chairman.
Further on the bill? Further on the bill? If not, Madam Administrator, please call the roll.
Roll call vote on House Bill 5422 to JF it to the floor. Winfield,
Winfield in the affirmative.
Staffstrom.
Yes.
Flexer, Quinn, Kissel,
Yes.
Fishbein, Blumenthal, Callahan, Conley,
Darn it.
Callahan,
Yes.
Curry,
Curry's a yes.
Delaney,
Delaney, yes.
Dillon, Doucette, Jubitsky,
No.
Elliott, Gaston,
Yes.
Gilchrist, Godfrey, Paul,
Yes.
Harding, Hayes,
Yes.
Howard, Johnson,
Johnson is yes.
Khan, Labriola, Lesser,
Lesser, yes.
Mar,
Mars, yes.
Miller, O'Day,
O'Day, no.
Osborne,
Osborne, yes.
Havelock Tomato, Porter, Sampson, Sims,
In the affirmative.
Beach,
Yes.
Walker, Wilson, Quinn,
Quinn votes yes.
Turning to number 20, House Bill number 5506, an act concerning families with service needs. Motion will be a JF. Is there a motion?
So motion.
Was that about Robert's Rules of Order again?
We have to go by Mason's.
Okay. All right, so we will have a motion from Representative Fishbein. We'll have a second from Representative Howard. Discussion on this bill. Madam Administrator, please. Senator Winfield.
I just want to jump in for a second, because I know that there were folks who came and had a lot of issue with the bill. So I just want to help people to see what is kind of happening here. So I've had a lot of conversation with Representative Fishbine about what the attempt here is. And I recognize that we have um, dealt with the issue of poison and made attempts to make sure that status wasn't criminalized and gotten rid of the petitions and the dockets and all of that stuff associated. And for that reason, if we were walking in a direction that the bill seems to suggest, the bill certainly would have costs associated with it, certainly go to appropriations and have a number of steps before it ever went forward. While I don't want to reestablish poison, I do believe in my conversations with Representative Fishbine that he's trying to figure out a way to deal with a real issue. And this is his attempt, and I've made attempts to do things and haven't quite hit the mark by the end of this committee, and that was not a reason to not try to keep going. And so because I believe that, and because, well, at the end of the day, I get to choose whether the bill's going to come out of the Senate or not, I will be voting in affirmative. And I don't want the folks who came here who had very valid things to talk about to think that they were ignored and not a part of this process. You have been heard. We're trying to see where this winds up. And if we can get it there, we'll get it there. And if we can't, we can't. But with respect to the conversation I've had and the long-standing relationship, I will be voting in the affirmative today. Thank you, Mr. Chair.
Further on the bill? If not, Madam Administrator, please call the roll.
Roll call vote on House Bill 5506 to JF it to the floor. Winfield, Staffstrom,
Yes.
Flexer, Quinn,
Yes.
Kissel,
Yes.
Fishbein,
Yes.
Blumenthal, Callahan,
Yes.
Conley, Curry,
Curry is a yes.
Delaney,
Delaney, yes.
Dillon,
Dillon, yes.
Doucette, Dubitsky,
Yes.
Elliott, Gaston,
Yes.
Gilchrist, Godfrey, Paul,
Yes.
Harding, Hayes,
Yes.
Howard,
Yes.
Johnson,
Yes.
Khan, Labriola, Lesser,
Lesser, yes.
Mar, Miller, O'Day,
O'Day, yes.
Osborne,
Osborne, yes.
Havelock Tomato, Porter,
This is 5422, correct?
5506,
Okay, I'm gonna pass.
Sampson, Sims,
Sims in the affirmative.
Beach,
Yes.
Walker, Wilson,
All right, we are gonna turn to, our final bill for the day, but before I do, which is gonna be item number 21, House Bill number 5507. Before I take a motion on that, I'm gonna turn to Senator Kissel.
Thank you very much, Chairman Staffstrom. On this particular matter, I'm going to recuse myself to avoid any appearance of impropriety. Thank you.
Thank you. The record will note that Senator Kissel is recusing himself. So House Bill number 5507 is an act concerning state agency and court proceedings related to electronic transmission lines. The motion will be a JFS LCO number 3484. Motion from Representative Fishbein, second from Senator Winfield. This is a bill that comes before this committee seeking to provide more rights and authority with respect to neighboring property owners and municipalities where a utility is seeking to site electronic transmission lines. This bill is particularly geared towards our densely populated, more urban areas by adding transmission lines to to our environmental justice statutes, and also providing for greater opportunity for local community and local elected officials to be heard on an application before it's submitted to the siting council. The bill also looks to empower the siting council to consider the economic impact of a potential project. You know, as we've seen in certainly in Bridgeport and Fairfield over the last several months, the siting council appears to be looking just at what the bottom dollar is in terms of how much does it cost to build a project, as opposed to what is the impact to a community? What is the impact to the economic prospect of that city? What is the economic prospect to the state of Connecticut? Which should be taken into account as opposed to just pure construction costs and decades of lost development opportunity that can and would flow. So with that, I'll take any questions on this bill. Seeing none, I'll ask for a roll call vote.
Roll call vote on House Bill 5507 to JFS it to the floor with LCO 3484 Winfield,
Winfield, in the affirmative.
Staffstrom.
Yes.
Flexer. Quinn.
Yes.
Fishbein.
Yes.
Blumenthal. Callahan.
Yes.
Conley. Curry.
Yes.
Delaney.
Delaney, yes.
Dillon.
Dillon, yes.
Doucette. Dubitsky.
Yes.
Elliott. Gaston.
Yes.
Gilchrist. Godfrey. Paul.
Yes.
Harding. Hayes.
Yes.
Howard. Johnson.
Yes.
Khan. Labriola. Lesser.
Lesser, yes.
Mar.
Mar, yes.
Miller. O'Day.
O'Day, yes.
Osborne.
Osborne, yes.
Havelock D'Amato. Porter.
Porter votes in the affirmative.
Sampson. Sims.
Sims in the affirmative.
Beach.
Yes.
Walker. and Wilson.
All right, we are going to take up the consent calendar in a moment. But before we do it, that will conclude our business for today. Also, we'll announce the committee will not meet tomorrow, considering the amount of business we moved today in short order. We will not meet tomorrow. We will be back in action on Thursday. All right, Madam Administrator, if you could call the consent calendar, please.
Consent calendar consists of Senate Bill 212, Senate Bill 427, House Bill 5055, and House Bill 5418. Winfield,
Winfield, in the affirmative.
Staffstrom.
Yes.
Flexer. Quinn.
Yes.
Kissel.
Yes.
Fishbein. Blumenthal. Callahan.
Yes.
Conley. Curry.
Curry's a yes.
Delaney.
Delaney, yes.
Dillon.
Dillon, yes.
Doucette. Dubitsky.
Yes.
Elliott. Gaston.
Yes.
Gilchrist. Godfrey. Paul.
Yes.
Harding. Hayes.
Yes.
Howard. Johnson.
Yes.
Khan. Labriola. Lesser.
Lesser, yes.
Mar.
Mar, yes.
Miller. O'Day.
O'Day, yes.
Osborne.
Osborne, yes.
Havelock D'Amato. Porter.
Porter votes in the affirmative.
Sampson. Sims.
Sims in the affirmative.
Beach.
Yes.
Walker. Wilson.
All right, with that, the committee will stand in recess until 4 o'clock for members to log votes. And also, as for Thursday timing, caucus will be at 10 again. And then the committee meeting will start at noon again. So we'll keep the same schedule on Thursday. All right, see y'all then.
Hello, can you guys hear me okay?
Yes, hi Kirsten.
How are you? Okay, so I'm gonna go. All right, so I'm gonna go in order for consent. For consent, do said Elliot Khan for the consent calendar.
Khan votes yes.
Labriola for the consent calendar.
Yes.
Miller, Havelock, D'Amato, Sampson, Walker, and Wilson. All right, for Senate Bill 349. Khan for 349.
Yes.
Labriola for 349.
What number on the agenda?
349
Both
is item 3.
Yes.
Lesser. Okay. Sampson, Walker. 357. Callahan, got you. Khan.
What number did you say? Sorry.
That's okay. 357 for number 4.
357, yes.
Labriola.
Yes.
Lesser. Okay, for item number 8, Senate Bill 445. Khan.
Yes.
Labriola.
Yes.
Lesser. Okay. For House Bill 5257, which is item number 10. Khan.
Yes.
Labriola.
Yes.
Lesser. Okay. 5258, which is item number 11. Khan.
Yes.
Labriola.
Yes.
Lesser. For House Bill 5508, which is item number 22. Khan.
Yes.
Labriola.
No.
Lesser. And Dylan, I need you for 55082. Representative
Yeah.
Dylan.
Yeah.
Okay. Senator Lesser.
Senator Lester, yes.
Okay. For House Joint 171, item 23. Dylan.
Yes.
Khan.
Yes.
Labriola.
No.
Lesser.
Lester, yes.
For House Bill 5297. Khan.
Yes.
Labriola.
No.
Lesser.
Lester, yes.
For 5324. Khan.
Yes.
Labriola.
No.
Lesser.
Lester, yes.
Miller. For 5380. Khan.
Yes.
Labriola.
Yes.
Lesser.
Lester, yes.
For 5412. Khan.
Yes.
Labriola.
Yes.
For 5413. Callahan.
Yes. And I'm done. Thanks.
Thank you. Khan.
I'm going to abstain.
Okay. Labriola.
Is this 5413?
That's correct.
Yeah, I'm a yes.
5419. Khan,
Yes.
Labriola,
Yes.
Lesser.
Lesser, yes.
Okay. 5422. Khan,
Yes.
Labriola,
Yes.
Lesser,
Yes.
and Dylan.
Yes.
Okay. 5506. Khan,
Yes.
or sorry, thought I said that wrong. Labriola,
Yes.
5507. Khan,
Yes.
Labriola.
Yes.
Okay. Then we did the consent. All right, so I think you guys are all set.
Thank you.
Great. Thanks. Thanks a
Thank you
lot.
so much.
Thank you.
Give me 1 second, Senator Gass.
Not a problem.
Okay, Senator.
Yes, I'm here. I
Um,
want to just make sure, I know that initially I missed some votes early on. Just want to make sure that I have all my votes in.
Real quick. So for Senate Bill 349, which is item number 3,
Yes. And then I wanted to go back to House Bill 35324. I voted no. I'm going to go ahead and vote yes for that. I got some better clarification. 5324. I voted no. I think it was the only no vote that I had registered.
5324. Yep, I see you as a no. You want to be a yes?
Yes, I want to change it to a yes.
Okay, I change you to a yes for that. And then let's see, it's amendment. Yeah, otherwise you're all set.
Thank you so much. You have a
Thank you so
wonderful
much,
day.
Senator. You too.
You take care. Bye-bye.
Hi, Kirsten. Oh, I'm sorry, Rep. Delaney. I didn't see you on the camera.
Ladies first.
Nope, after you.
Yes, ma'am. Madam Administrator.
Hi, Representative and Senator Miller as well.
Hey, Madam Administrator.
All right, so I'll go through everything. Um,
I just wanted to see if I missed any bills. I think I might have missed the first one.
let me take a look. So I have you for consent, Senator Miller for consent?
Can you tell me what's on consent, please?
Yes, absolutely. Consent was item, number 1, Senate Bill 212. It was item 5, Senate Bill 427. Item number 9, which is House Bill 5055. And then it was item 17, 5418. Those 4 bills.
Okay. All right, I vote yes for the consent.
For Senate Bill 349, how would you like to vote?
I think Rep. Delaney wanted to know what he missed.
Thank you.
You didn't miss anything. You're all set.
Thank you. Bye, everybody.
Have a good day.
You too. And thank you for all the hard work today.
You're welcome.
Did we skip any today before
We
I
did.
vote? Which
Yep,
ones
we
did we skip?
skipped.
I know we skipped 2 and 7.
We skipped 2, 6, and 7.
6 and 7, okay.
Yep.
And which number was the child support through 21? Was that 20 or 21?
We didn't have that on today.
Oh, it wasn't on today, okay.
Yeah, I don't believe so.
I thought,
No.
okay. So, I'm ready for you.
Okay, for Senate Bill 349,
Yes,
for 357,
yes,
for 445,
yes,
for 5257,
yes,
5258,
yes,
5508.
5508,
Yep.
yes,
For House Joint, the last one, 171,
yes.
for 5297.
Oh, so you went back, okay.
Yeah, sorry, we were jumping it. Yeah,
Yeah, that's what I'm looking, I'm going, oh.
I know.
So 5297, I
Yeah.
want to make it a matter of record. I will vote yes to get out of committee, but I don't know how I feel once it hits the floor.
Okay,
I don't know what my position will be once it hits the floor.
okay. Okay. For 5324,
5324. Same thing. I'll vote to get it out of committee, but I don't know what my position will once it hits the floor. So I'll vote yes.
for 5380,
Yes,
5412,
yes,
5413,
does that have JFS language?
It does.
It does, right?
That's right, yeah.
So I think, yeah, okay, that was one. Yes,
Okay. For 5419,
yes,
5422,
oh, 5419. That was the wrong one. Okay, yes,
5506,
Yes.
5507,
5507,
yep,
yes.
and that's it.
Um, can we, how can we do this? Can we not, can I call you back? Can we not register me for 5506 and 5507? I had a question. I need to go and check it out, and then I'll call you right back.
Yeah, of course, votes are open till 4.
Okay, thank you.
Of course,
Bye.
Summer. Hi, Senator.
Hi, thank you for your patience.
Of course.
Let me know when you're ready.
Grab these two. All right, so for 5506.
Right, 5506, I voted to get it out of committee,
Okay,
but my position may change once it hits the Senate floor.
okay. And then 5507.
5507 is a yes.
Okay.
All
All
right.
right. You're all set then.
Thank you.
Thank you. Have a good one.
You too. Bye.
Hey, Representative, how are you?
Hi, I'm okay, except I'm multitasking today and I apologize for that.
No, you're
I
fine.
believe I'm checking on my vote on the secondary violations bill.
So
I
for
was
House,
I was in another meeting and I want to make sure that it's recorded correctly.
so you voted yes for that.
On secondary violations, I did.
Yes, on 5324.
The members think I voted no.
I have you as a yes.
Okay,
But
I
before
was
you
on,
leave,
yes,
I want to get the other ones because you did miss a couple others.
okay.
For Senate Bill 349, which is item number 3.
Okay, let me look at my agenda. I really apologize for this. It's a fluke that I happen to have a lot of things at once and I missed some things too.
No, I'm doing that with a number of other members, so it's not just you by any means.
Okay, number 3,
Yep, for 349.
is that the dyslexia bill?
Yes.
Yes,
Okay. Let me just make sure that may have been the only one I just put. Well, I have you. So I thought I had you, and then when I just went through, I was gonna reach out. So I'm glad that you got back on.
well, one of my meetings ended.
It's the one less off the plate. All right, so that's it. You're all set.
Okay, but that's good. Thank you so much.
You're welcome. Have a good one.
Good, thanks.
Hello.
Thank you so much. For the first, for item number 3, Senate Bill 349.
I will be in the affirmative.
And then for Senate Bill 357.
357.
Yep.
I'll be in the affirmative.
Okay. Oh, and then for Senate Bill 445.
I will be in the affirmative.
House Bill 5257.
I didn't realize I missed all these bills. Okay.
I know. Well, in your audio had gone a couple times and we tried, and it just, so I figured I would go back to you.
Yeah, 52, 57, I'm in the affirmative.
Okay, and then 5258. And I think that might be the last one. Double check.
Yes.
Okay, let me stay there one sec. Let me just make sure. I think those are it. Yep, you're all set. Thank you so much, Senator. I appreciate it.
Take care.
Hi, Representative.
Oh, there we
There you
go.
go.
So I know I missed 10 and 11, and I vote yes for both of those.
All right, hang on. Let me do real quick. Can I do the consent calendar?
Yes.
Okay, cool. All right, so it was such a funny day. Everybody was saying so 10, you said, which is 52. You said yes on that.
Yep.
Okay, and then 11, which is here. Yep, you saying yes?
Yep.
Okay, and then have you? I think it was one. Maybe I'm wrong, but
I,
oh, okay. And
I
then
missed 19 through 21 if it was brought up.
yeah, 19 exactly right. So 5422. How do you want to vote?
Yes.
Okay, and then 5506.
Yes.
And oops, and then 5507.
Yes.
Excellent. You're all set.
And then the consent calendar, that just was the one, it was Senate Bill 212.
Yep.
It was Senate Bill 427
Yep.
and House Bill 5055
Yep.
and then House Bill 5418, correct?
That's correct. Yep, those four.
Perfect. Thank you.
Thank you. Have a good one.
You too.
Hey, Christian.
How are you?
I'm good. Could we change my vote on the secondary stop bill?
Yep. So you voted yes.
Did I?
Yes, you voted in the affirmative.
Okay. I thought I voted against it.
Nope. Yep.
All
You
right.
voted yes.
This is ACLU's priority bill, right?
I'm not sure, to be honest with you, but
Okay.
I believe so.
Awesome. All right.
Okay.
So if I'm a yes on it, then all is well. Then thanks so
Okay.
much.
Of course.
All
Take
right.
care.
Yep. You too.
Bye bye.
Bye bye.
Hello, Kirsten.
How are you?
Oh,
Thank you so much for jumping back on.
Yeah, I hear you.
Can you hear me okay?
I do.
Okay.
I am quite certain that I voted on every bill. I was
Yeah,
there
you
all the
were.
time.
Yeah, exactly. We had kind of some audio issues, so that's why I just wanted to make sure. So for Senate Bill 357, it's the Union Avenue Detention Center in New Haven.
I'm a no on that one.
Okay. And then for Senate Bill 445.
I'm a yes on that one.
Okay. Otherwise, I have you for everything else. You're all set.
That
Thank
it?
you so much. Yeah, I appreciate it.
Okay, thank you.
Take care.
Bye.